We've got massive ATF news that could restore gun rights to thousands of Americans. And it's the first time in modern memory the agency is talking about narrowing a prohibition instead of expanding one. If you've ever been denied at the counter, warned off by a friend, or you take a medication you thought made you ineligible, listen closely. Subscribe to Gun and Gavel right now, because these rule changes move quietly, and most people only learn about them after they're already in trouble. This video is education, not legal advice. Laws vary by state, and if you're dealing with a real denial, talk to a qualified attorney. Now, here's the context. For 50 plus years, when the ATF clarified something, it almost always meant more people became prohibited, more items became regulated, and more ordinary owners got caught in the net. That pattern is exactly why this proposal is such a shock. It doesn't just tweak paperwork. It targets one of the broadest, most abused categories of federal prohibition, the unlawful user rule tied to drugs. If it becomes final, it could change denials, prosecutions, and even civil cases, but only if gun owners understand it and comment today. Since 1972, the Bureau of Alcohol, Tobacco, Firearms, and Explosives has issued hundreds of interpretations that act like law in the real world. Researchers tracking those memos and rule letters put the number above 300, and the overwhelming majority tightened access, expanded definitions, new paperwork, new registration demands, or reclassification of items people already owned legally. Firearms attorneys joke that when the ATF says guidance, they hear handcuffs, because a single paragraph can turn yesterday's normal purchase into today's felony. The troubling part is that these aren't statutes passed by Congress. They're administrative decisions made by officials you never voted for. Yet they can still trigger raids, seizures, and prosecutions. Between 2000 and 2020, enforcement data cited in multiple briefs estimates roughly 1.8 million owners were pushed into technical noncompliance after reinterpretations, meaning they had to modify, register, or surrender property they bought in good faith. And the average gun owner has no practical way to track all of it, because the rules move faster than public awareness. That's why this proposed change is so unusual. It moves the other direction, away from a blanket ban and toward a court-defined, evidence-based standard. And it could reshape how bans are drafted. Right now, the flashpoint is 18 USC 922 G3. The federal ban on firearm possession by an unlawful user of controlled substances. Under current enforcement, about 12,000 purchase denials per year are tied to this category alone. The shocking part is what can trigger it. A single possession arrest, even if dismissed. One positive drug test from an employer, a probation screen, or a medical program. Or a person who answers too honestly on Form 4473 about past use, thinking the question is historical rather than current. In practice, people have been treated as lifetime prohibited based on events that would never prove ongoing drug abuse in any other setting. Court records from 2015 through 2023 show tens of thousands of challenges to prohibited status, arguing that isolated, old conduct should not erase a constitutional right forever. Yet only a small fraction succeeded. Scholars call this a rights desert. The right exists on paper, but the process to regain it is so expensive and confusing that most people give up. The agency has also used a rough one-year look-back, treating any use within 12 months as current, even when the evidence is thin and the person is otherwise law-abiding today. Here's the legal problem. Federal appellate courts have repeatedly said unlawful user is not a vibe, it's a pattern. The 5th, 9th, and 11th circuits, among others, have required evidence of current, regular, and habitual use, not one-off experimentation or a stale incident months ago. Yet for decades, the ATF enforced a broader rule anyway, denying rights on evidence that would not survive in a criminal courtroom. Reviews of suppression litigation from 2018 to 2024 show judges rejecting the government's unlawful user proof in a majority of contested cases when it relied on a single positive test, one purchase, or gaps of weeks and months between alleged use. That's backwards due process. In America, you're supposed to keep your rights unless the government proves you should lose them, and the proof standard should be higher, not lower, than what would be needed to convict. What makes this moment different is that the agency is finally acting like it has to listen to courts. Not because it suddenly became friendly, but because the gap became impossible to defend after repeated losses and growing pressure. And if you've ever been denied over prescriptions or old use, this proposal targets you right now. So what is the ATF actually proposing? 5 shifts that sound technical but change real lives. First, a single drug possession or use conviction within the last year would not automatically make you prohibited. The government would have to show regular use, not one incident. Second, one positive drug test within 12 months would not create an automatic presumption of current use. They'd need multiple tests or other evidence showing a pattern. Third, self-reported past experimentation without recent proof of ongoing use would no longer be treated as a confession that triggers a ban. Fourth, lawful use of controlled substances under valid prescriptions or recognized state authorization would not, by itself, create prohibited status, a provision that could impact medical marijuana patients in dozens of states. Fifth, the rule would explicitly require proof of recent, regular, habitual use, aligning the agency standard with what appellate courts already demand. ATF denial data suggests thousands each year were blocked mainly because one test or one incident was treated as proof of current use. Narrowing the standard could restore rights to many people who were never habitual users. If this touched you, comment with the basics, because detailed feedback shapes what happens next. Now comes the part most people skip, the public comment period. It's open until June 30th, and administrative law forces agencies to read, categorize, and respond to significant points. Comments are not just votes. They become part of the record that courts review if the rule is challenged later. History shows they can matter. In 2015, when the ATF floated a move against green tip ammunition, they received tens of thousands of comments quickly, and the proposal was pulled. On pistol braces, the agency received hundreds of thousands and still went forward, but it had to answer arguments and expose weaknesses in its own reasoning. If you want your comment to count, don't just write, "I hate this" or "I love this." Explain the real-world impact, ask for definitions, and point to court cases that require recent, regular, habitual use. Ask how the agency will handle state medical authorizations, what evidence triggers a presumption, and whether people previously denied will get a streamlined path to review. Personal testimony matters too. Dates, outcomes, and the costs of being wrongly labeled prohibited. And if you want updates as the docket moves, subscribe to Gun and Gavel, because this part happens fast and quietly. Why does this matter beyond drug-related denials? Because agencies rarely shrink their own power voluntarily. If the ATF admits its old approach was broader than courts allow, it becomes harder to defend other overreach built the same way. Scholars of administrative law call this a precedent effect. Once an agency starts aligning its definitions with judicial holdings, litigants can point to that alignment in other fights and ask, why not here too? Think about other prohibited categories and other rules that depend on aggressive interpretations. If isolated use doesn't make you a current user, what about a single decades-old misdemeanor used to bar someone for life? If a doctor's prescription can't be treated as disqualifying drug use, what about other medical conditions the system treats as red flags? The timing also matters. Since the Supreme Court's modern Second Amendment decisions, more federal judges are demanding history and tradition support for gun restrictions. and several courts have questioned whether 922G3 is constitutional as applied to nonviolent people. The ATF may be narrowing enforcement to avoid a worse outcome, courts striking the prohibition down entirely. That doesn't make the agency your friend. It means pressure is working, but only if the public stays engaged. One huge unresolved issue is retroactivity. If the final rule says the old standard was too broad, what happens to people already denied under it? The draft language in many agency proposals is silent on whether past denials get reevaluated automatically, whether records are corrected, or whether people must simply try again and hope the system now applies the new definition. That matters because federal rights restoration paths are slow and expensive. For felonies, legal fees can run into the 5 figures, processing can take years, and success rates are low. If people tagged under 922G3 have to fight like felons just to be reconsidered, the practical benefit of the rule shrinks fast. That's why some attorneys are already discussing class actions if the agency finalizes a narrow definition but refuses to fix the backlog of wrong denials. The argument is simple. Equal protection and basic fairness require that similarly situated people be treated under the same standard, not punished forever because they applied last year instead of next year. Even if there's no automatic restoration, at minimum, the ATF should publish a clear, cheap procedure for reconsideration. Without that, the rule becomes good news in theory and useless in practice. Denial statistics also hide the biggest group, people who never even attempted to buy. Surveys and interviews over the last few years suggest millions of Americans decided not to purchase a firearm because they assumed a prescription, a medical cannabis card, or some past experimentation made them prohibited. For every person who gets a denial letter, many more self-prohibit because they don't want to risk a felony for a wrong answer on Form 4473. That chilling effect is huge, and it's almost never counted in policy debates because it leaves no paper trail. If this rule becomes final and is communicated clearly, a lot of people may discover they were never legally barred in the first place under the court-defined standard, or that the bar is narrower than they were told. The problem is that fear lingers. After years of hearing one mistake equals a lifetime ban, people won't change behavior overnight. Clear guidance and public education matter as much as the text. It can take years for people to unlearn fear and try again. If you skipped a purchase because you thought meds or past use disqualified you, say so below. Those real stories show the true impact today. So here's the bottom line. For half a century, ATF updates have usually meant tighter rules and more people losing rights. This proposal is different because it tries to bring enforcement back to what courts have been saying all along. The government must prove recent, regular, habitual, unlawful use before it can take away Second Amendment rights. If you support narrowing an overbroad prohibition, use the comment period and be specific. If you oppose it, be specific too. Either way, silence lets the agency write the record without you. And remember, none of this changes your obligation to follow the law as it exists today. Until a final rule is published, and until courts interpret it, treat the current rules seriously and get legal advice for your personal situation. If you've had a denial, save your paperwork, because details matter later. If you're a medical patient, document your authorization and talk to counsel before you buy. If you're a friend helping someone, don't guess. Check the statute and current guidance. If this helped, hit like, share it, and subscribe to Gun and Gavel. I'll cover the final rule the day it drops, for you. Stay informed, stay protected, stay free.